Hi, I'm Emily, and I am here with Maya Murphy's attorney, Eva Marie Franco Fox. Attorney Fox practices at Maya Murphy in Westport, Connecticut, and is admitted to practice law in both Connecticut and New York. My question today for Attorney Fox is, my fiance and I each have children from our prior marriage. We agreed to leave one half of our combined assets to my children and the other half to my fiance's children. If we agree to divide the assets this way, do we still need a prenuptial agreement in Connecticut? Can't we just include this language in our wills?
That's a good question, Emily. We often find that partners are trying to utilize alternate means of memorializing these informal agreements that they've reached with their significant others rather than use a prenuptial agreement or a postnuptial agreement. They're concerned that if they suggest a prenup or a postnup to their significant other, it may offend them. And so they're trying to use other tools such as estate planning to memorialize these agreements. Unfortunately, in Connecticut, using an estate plan to try to compel your spouse to distribute their assets in a certain manner or otherwise to clarify what the financial and property rights of the spouses are is really not an effective tool. That's because in Connecticut, a will is specific to one person. So even married individuals who have the same estate plan in mind each need their own separate wills. It's not a joint document, and it certainly isn't a joint contract between two individuals. So this way, each individual has their own will, and they're free to amend their will or revoke their will at any time. And you can't compel your spouse to provide you some kind of consent or obtain your or put you on notice if they want to revoke or amend their will. And so we have a situation where perhaps your spouse is going to change their will without letting you know, certainly without your consent, either during your lifetime or after your death. And you can't control that, you can't change that with a simple estate plan. So in the scenario you provided, we have individuals who agree, yes, in the event of I predecease you, I will leave all my assets to you, and then upon your death, you can leave 50% to your children and 50% to my children. And if you predecease me, I promise I will leave 50% to your children and 50% to my children. Well, what if you predecease your spouse and they remarry, and now they want to leave a certain portion of the assets to their new significant other, their new spouse? You can't control that. You can't prohibit them from doing so. Perhaps they want to leave all of the assets to their new significant other. Your children are effectively disinherited when you thought they were going to be provided for. And again, there's no way for you to compel them, certainly after the time of your death, not to change their will. So we have a scenario where you essentially are inadvertently disinheriting your children or disinheriting your loved ones, even though your significant other and you reached some kind of agreement on how your assets would be distributed upon your deaths. So in Connecticut, really the best way to effectuate your estate plan here is to enter into a prenuptial or postnuptial agreement. Now, some individuals will say, well, I will just, in my own will, leave 50% of the assets to my children, and then at least my children are cared for. And if my significant other remarries, they're free to do whatever they'd like with their other 50%. Now, the concern here is that you may not own 50% of the assets at the time of your death. Now, the way that your estate works at the time of your death is that 50% of the assets in your name may be left to your children, right? And so if you have any assets that are held jointly, likely they are going to be held with the right of survivorship. That's commonly how joint assets are held, which means that they will pass automatically to your significant other, your spouse, at the time of your death, rather than go into your actual estate at the time of your death. And certainly if there are any assets held solely in your spouse's name, they would not pass through your estate at the time of your death and therefore would not be subject to distribution amongst your children at the time of your death. So it's really only the assets that are in your sole name that will pass through your own estate at the time of your death. And so some people will say, well, fine, I'll just put 50% of the marital assets in my name, and so therefore I can leave my 50% to my children. I'll ensure that they're held properly with the right title. Now, this is also not an effective tool in Connecticut because in Connecticut we have what's commonly referred to as an elective share right, which means that spouses have the right to essentially opt into receiving up to a certain amount of their significant other's estate after their death if they've been disinherited. So in Connecticut, you are prohibited from disinheriting your spouse. So what does this mean on a functional level? It means that if you prepare an estate plan, even if it's valid and otherwise enforceable, to the extent that you've excluded your spouse has the right to opt into receiving up to 1/3 of your net probatable assets after your death, even if it's against your wishes and against any kind of informal agreement that you reached with your significant other. whether you have children from a prior marriage, whether you have other dependents that you are wishing to provide for. So this way, your significant other would still receive whatever assets are still in their sole name or whatever assets passed to them via joint ownership, and up to 1/3 of your assets that you intended to leave to your children. So as you can see, this can really backfire. It can end up really essentially disinheriting your children or significantly reducing the assets they would have otherwise received inadvertently. And so again, the best way to ensure that your agreement with your significant other is going to be honored, is going to be enforceable, is to enter into a prenuptial agreement or a postnuptial agreement. And prenups and postnups can include what's known as a waiver of estates rights. And that's essentially a waiver where both parties agree that they are not going to and cannot essentially invoke their elective share rights. So they're not going to interfere with one another's estates plans after their spouse's deaths. And the agreement can also specify which assets are going to be left to which individual, and this way they can essentially effectuate any kind of estate plan that they reached, any kind of agreement that they reached, in a way that they can both ensure will be enforceable. A prenuptial agreement and a postnuptial agreement is a contract, and therefore, in order to revoke it or amend it, both parties need to be on board. They both need to have notice. They need to agree to the amendment or agree to the revocation. So therefore, you're not in the same situation that you would be if you just memorialize this agreement in an estate plan, where both parties are free to essentially amend or revoke without the other's knowledge and consent. With a prenup or a postnup, both parties need to be on board if they're going to deviate from this plan. So really, we encourage you to consult with an attorney if you have any questions about providing for children from a prior marriage or other dependents. And certainly, if you have any questions about how to make sure that your estate plan and your prenuptial or postnuptial agreement are working in tandem with one another rather than against one another.
Attorney Fox is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Fox at efox@mayalaw.com, and please visit mayalaw.com for more information.